Well, good afternoon, everyone. It's a privilege to be presenting to all the CBAC members. We've worked with many of you guys over the years, and it's a great organization. It's always nice to be able to have an opportunity to speak to the group on developments in the SBA's regulatory world. I'm just going to jump right into the slides so that you guys can, we can just make as much progress as possible here, getting into the nuts and bolts of what's been going on with the SBA. I'm hoping to take some questions at the end. As John said, my name is Tony Franco. For those of you who don't know me, I'm a senior partner at PilieroMazza, and I run the firm's government contracting group. Been doing this for, well, as a government contractors chair for about a few years, but I've been with the firm practicing government contracting for 30, following these issues involving small businesses. In our firm, that is basically our bread and butter, which is representing government contractors in all the legal issues they face, not only on their government contracts, but also on their labor and employment issues, their corporate issues, and litigation. But with the bulk of all our work representing government contractors that are small businesses, and many of which are mid-sized and grown, and now are teaming with smaller businesses and trying to take advantage of these rules that allow them to continue playing in the small business arena, such as Mentor-Protégé and joint ventures. Just to give you guys an overview of what I want to discuss today, this all has to deal with the SBA's new rule that just went into effect a couple days ago on the consolidation of the SBA's Mentor-Protégé program for small businesses with the 8A program. Now, that's what this rule is been called and known for, because when the SBA issued it as a proposed rule at the end of last year, about a year ago, it was a big event because these two programs were operating, and it seemed to be really not necessary to have these two different programs. And so the SBA took that opportunity to then not only consolidate the programs, but also they amended a number of SBA regulations. For many of you, the ones that you may be particularly interested in are those involving joint ventures. There were also revisions to small business rules generally, and also revisions of the 8A program rules. And there are a lot of other areas of the SBA's regulations that were revised. This was almost 60 pages, single-spaced, of rules in the Federal Register, which impact different aspects of small businesses. What we are going to be focusing on today during the next 45, 50 minutes is going to be the big ones that I think you'll be most interested in. But keep in mind that there's other rules out there that were also changed that you need to be mindful of. And if you reach out to our firm, we can send you material. We've been publishing a lot of things regarding these new rules. It's just a matter of whether we would have the time to go through all of that today. It could easily take 2-3 hours. But I will touch base on the big ones right here that are being discussed. First one is here, the fact that they've merged the 8A Mentor-Protégé program into the All Small Business Mentor-Protégé program. In a nutshell, that really should not impact any firms except those that are in the 8A program, and that they are now really no longer in the 8A Mentor-Protégé program, they're in the All Small Business Mentor-Protégé program. At the end of the day, this is really makes a lot of sense because the SBA had a group of people reviewing Mentor-Protégé applications for the 8As, but then there were all these other applications going through the All Small Business program. And we were finding that it was easier to just get into the All Small Business program. And so the SBA, we were telling many 8A companies just apply there, which is what they were doing. So what the SBA has done is basically, there's no longer an 8A Mentor-Protégé program. What this does mean, though, is that the All Small Business Mentor-Protégé program is likely going to face a significant number of applications. And we've seen this happen now for a while because of these big contracts that are being awarded. So many small businesses of all different socioeconomic groups have been applying for the program in order to joint venture. And so it's really, really going to be hard to compete as a small business unless you are joint venturing with another company. And normally you have a significant competitive advantage if it's a large business mentor. So we just think that this means that if you're planning on entering the Mentor-Protégé program to joint venture, you've really got to plan ahead because it's taking longer and longer to get in the program. One of the things to keep in mind regarding the new rule is that if you were denied the ability to apply for the program. That does not, you do not have an opportunity to seek reconsideration anymore. But basically they've indicated is that you need to wait 60 days and then reapply. Okay, you can reapply with the company that you were originally rejected with, or you can seek a new mentor. If the SBA has denied your mentor-protege application, and you see that the reason is a big one that may be hard to overcome, then I think you need to pivot and find yourself another mentor, which could take time, right? You just can't. We always tell clients, be very careful who you're mentoring with. And we tell our mentor clients, be careful who you're doing the mentoring to, because you want to make sure it's a solid relationship. One of the big issues here that has come out of this new rule, it's not that different from the old one, but that clearly the SBA is focusing on, is whether the mentor can demonstrate that it's committed and is able to assist small businesses. So when we're normally getting these mentor-protege applications to review for our clients, the one area that we really focus on is what are the needs of the protege and what is the mentor going to do to help that protege satisfy those needs. And there is a boilerplate mentor-protege agreement. Legally, there's not much we do with it, but what we do, given our experience, is tell the clients when they need to drill down deeper by connecting what their business plan of the protege has and what the mentor is going to be doing, and then the mentor being able to show how they're going to be doing it. Keep in mind that there are some, there are limitations with regard to how many mentor-protege relationships companies can have that they've created for Puerto Rico because of the economic situation there in the hurricane. Some exceptions, which I'm not going to get into since it's so very unique to Puerto Rico. You should note that one of the big things that we think this rule does, which we think is good, is it does allow a company that is in a mentor-protege relationship that determines early on that it's not really working out to get out of the relationship. We have seen during the course of the last 5, 6, 7 years that the all small business mentor-protege has been around. And we had also seen it with the 8A mentor-protege programs that have been around since the late, like 1998, 1999, that there are situations that people get into that they later really regret. And it's because they haven't really done any business together. They're very interested in going after a JV. And all of a sudden, after they get into the mentor-protege relationship, they are not getting along. And a lot of times that is a product of negotiations of the joint venture. Under the rules that have been in effect until until the 16th, once you've been entered the mentor-protege program, if you're a protege, you've used that one of your two up. And so a lot of companies were saying that they were now deprived of 2 mentor-protege relationships because that first one didn't work out well really early on. And the SBA did have some regulation that suggested they were going to be policing this, but really nothing was coming out of it. But at the end of the day, what the SBA has done is they're letting the proteges know that they are able to get out of these relationships and not have it counted against them if they do it within the first 18 months of entry. I should tell you something I tell all our clients is that they should really think about whether they want to go ahead and joint venture, whether they want to do a mentor-protege without first negotiating a joint venture agreement. Because if you do the whole mentor-protege process and then you can't really negotiate a joint venture, you've really wasted your time because people are doing this in order to JV. So we think it makes sense to first negotiate your joint venture agreement when you know what the terms are and that there's no disagreements, then move forward with the mentor-protege. And I've seen that work on a number of occasions, and I've seen how companies walk away from the mentor-protege relationship because of the joint venture. One of the things that the SB has also done with regard to the new rule is indicate that they want the proteges to essentially provide feedback to the SBA on an annual basis regarding how is the mentor performing, which means obviously that mentors have to be mindful of the fact that they can be essentially getting graded in the work they're doing with the protege. So they want to really have a good, solid relationship with them. And the proteges also then need to be pretty straightforward, because if they're giving annual submissions, which says all kinds of great things about their mentor, but then all of a sudden things go sideways, there may be questions as to, what really is going on here. But the SBA will always, if push comes to shove, side with the protege from what we have seen. And so the way we're looking at this program evolving is that they're putting more teeth into it. As many of you may have heard, there was actually a report issued by Congress regarding the way the program was working, that the SBA was criticized because it didn't feel it was being monitored well enough. So this is a product of that report, those reports that came out from I think the GAO, and I think a congressional one as well. So we saw this coming, and when this program actually first was launched, the SBA did study the potential for abuse. With regard to limitations and requirements, one of the things we also see with the rule that is important is it's allowing companies to look at entering into these mentor-protege relationships on their secondary NAICS codes. The way the program was originally structured is that the SBA assumed that companies would want to participate in the program, but in order to develop within their primary NAICS code. But some companies, really, they're doing okay within their primary NAICS code. They may actually even be large under their primary NAICS code, and it's under the secondary NAICS codes they want assistance. And the SBA has indicated that they will approve those. However, you can't go to the SBA and seek approval under a secondary NAICS code if you've done absolutely no work within that area, within that NAICS code. Now, if you've done work within a fairly similar NAICS code, then you can show how this is a logical progression for you to have a mentor within this other code, the SBA could approve it. But if there's not that kind of history, and we have seen companies that have come to us and they want to enter the program under codes where they've done no work, the SBA is just not going to approve it under the new rules that just went into effect. Now, another rule that the SBA has changed, this is now pivoting from mentor-protege to joint ventures. As you likely all know, the reason many companies do the mentor-protege relationship is so they can joint venture with a small business, or a small business with a large business, to go after small business set-asides or SDVO, 8A, HUD zone contracts. And there was this rule called the 3 and 2 rule that has been in place for a number of years. It's been very confusing. I mean, for us lawyers, it's been the kind of, it's generated revenues because constantly getting calls from clients asking us, like, what does this rule mean? And so, we explain it to them, we give them examples, etc. And I have to tell you that every time that I got one of those calls, I actually pull out the regulations because they're a mouthful. What they ended up doing is they basically got rid of the 3 award part of the rule. I'm not going to get into what that meant before because it's just no longer relevant. You should just know that under this new rule, if you create a joint venture with your mentor or another small business, you will not be deemed affiliated with them if that joint venture, after it receives its first award, receives 6, 7, or 8, 9 awards within 2 years of that first award. After the second year, when that 2-year mark hits, whether you've received only 1 award or you've received multiple awards, you have to stop bidding. That joint venture will now be radioactive with regard to a potential finding of affiliation because it's continued to exist beyond 2 years and continued bidding on work. But any proposals that were submitted prior to those 2 years can be awarded to that joint venture, and that joint venture can actually perform, many, many contracts, not just 3. Also, one of the things that is interesting, which the old rule also had, is once you've hit that 2-year mark, all you need to do is create another joint venture, form a separate limited liability company, and you're off to the races again. Now, this is a pretty big loophole because it really does allow you to operate under joint venture arrangements for a lot of different contracts. But the SBA has also made pretty clear that if they think you're doing this too many times and you're taking advantage of it, they could find an affiliation. And this could be the case even with a mentor-protege joint venture. Okay. Now, there is a case out there that indicates that the 3 and 2 rule, and I would think now even this rule, doesn't apply to mentor-proteges because the SBA's Office of Hearings and Appeal held at one point in time that the exception for affiliation under mentor-protege is so broad that it made no sense to apply the 3 and 2 rule. And that's still on the books. Now, interestingly, the SBA's regulation, in some commentary we've read, indicates that they believe that it does apply even to mentor-protege, but it hasn't been written that way. What we tell our clients, even though you have this case that would allow mentor-protege to just ignore this rule is still follow it, because you can't create multiple JVs. And just think that at some point or other, there may be a case that establishes how many more of these you can have. An important aspect of this new rule too is that now for 8A companies, they no longer need to get the SBA's prior approval for the award of an 8A contract to an 8A JV. They do need the SBA's prior approval if it's a sole source award to an 8A JV, but not if it's a competitive one. The SBA is basically taking the position that the market will police itself, and that if a company that loses a contract to an 8A JV believes they perhaps did not structure the JV properly, then you protest it, and that's how it gets scrutinized. I think this frees up the SBA's district offices, who had to spend a lot of time reviewing joint venture agreements. And it was really a major pain, because you needed to submit these JVs, shortly after proposals were submitted, and then you're keeping your fingers crossed that the SBA approves it. You sometimes have to go back and change this. This is going to make it much easier for 8A firms to JV on competitive work. However, it doesn't mean they need to do it right at the outset, because if they get protested, it'll be a size specialist who will be looking at the JV agreement. One of the other issues that came out of the joint ventures is regarding novation of contracts. We are finding that oftentimes companies want to go ahead and create joint ventures. And in order to establish past performance within a joint venture, they novate a contract to the JV. And then the issue arose as to, well, how does a novation of a contract work, since you really haven't submitted an offer? And the SBA addressed that issue, saying that if the clock begins to run when there's a first award, or if there's a novation of the contract. Now there is an issue, because if a novation could be approved after the 2-year period, because you submit a novation package to the contracting officer for approval, and it could sit for a while. And so the issue is, well, do they really have that contract if the novation has occurred between the parties, but it hasn't been approved? So at the end, SBA has indicated that if a novation could be approved after the 2-year period, and it would still then be okay. It would not impact the affiliation determination. The other thing the SBA dealt with is this issue regarding facility security officers. We've been regularly contacted over the years by clients who are pursuing contracts that indicated that the offeror needed to have a security clearance. In a lot of these JVs, they're unpopulated, and the security clearance officer resides in one of the parties, normally the small business or the 8A firm, etc., or STVL, for example. And the SBA basically indicated that these JVs may also be populated not only with administrative personnel, because that's always been understood that an unpopulated JV could have administrative personnel, very minimum, but a group that just handles the G&A and overhead, but they can also have the facility security clearance officer. And so that, we believe, has clarified a lot of things for small businesses creating these JVs. We have some questions as to how this still will result in agencies evaluating, because as I think a later slide shows, there's also references in the regulations to how past performance should be determined. And a lot of this, I think, is going to depend more on the procuring agencies and what the SBA says. Another issue the SBA tried to address was, how do you basically consider revenues of joint ventures? The SBA's rules have always indicated that a company, in determining a company's size, if they have a joint venture, they count their proportionate share of the joint venture's receipts. And the SBA has tried to clarify this further by indicating that it really comes down to how much work each party did, which is really the way it would work anyway, because under the rules the SBA has had in place, you perform work, you have to perform a certain amount of work, and you should have receipts based upon that amount of work. So it should automatically flow down that way. But there were some issues that were arising regarding what happens if you have a joint venture with, a 40-60 work split, but a 51-49% ownership split, which is very common. And then how do you go ahead and then report that? You have to report 51-49, which I never thought made sense, because it's really your receipts, and your receipts come from the work you're doing. But the SBA has tweaked those rules to make it clear. And they've also indicated, which we think is interesting, is that under the SBA's regulations have been in place for years, you get profits commensurate with the work you do, meaning if you are for argument's sake, a service disabled veteran-owned small business who has a 51% ownership interest in a joint venture, but has a deal with your mentor that you're only going to do 40% of the work on the JV, you can only keep 40% of the profits, even though you're a 51% owner, because the rule said, no, you only get profits commensurate with the work you did. The SBA's basically changed that and said, no, they can agree to get more of the profits. So it gives the small business or 8A firm or service disabled veteran more leverage at the time of negotiations. I mean, we think that's good because we do see some situations where it was on a regular basis, you have these contracts that were basically being performed by large businesses with them doing 60% of the work and getting 60% of the profits. The other issue that the SBA dealt with was how you apply the calculation of work performed by a protege. And so they dealt with issues concerning supplies, construction, and mixed contract, and how they apply to joint ventures, because there's been some questions regarding how the performance of work was going to be, how it's calculated. And it really is calculated the same way it would be for any small business that is performing a contract. If the joint venture is awarded the contract, they need to meet the minimums required of that prime contractor. And then they need to follow whatever rules apply, whether it's a supply, construction, or service contract. And if you create a joint venture where the protege is going to perform 40% of the work, the protege must perform 40% of the work of that JV. They can't bring in another similarly situated entity to do that 40%. The similarly situated rule that the SBA has for subcontract limitation purposes does not apply within the JV in the performance of work requirements. And this is a good clarification because the SBA has always said that the way work is counted and distributed within a JV should follow the way the subcontract limitation rules work. And so we've always looked at both rules together to get guidance because the joint venture rules for all these programs never really were that clear. But now it's pretty clear that the small business protege in the JV needs to do no less than 40% on its own. Now, some of the other rules that the SBA issued involved affiliation, size, and status rules. As I mentioned at the beginning of the call, the SBA's regulations dealt with more than just the merger of the Mentor-Protégé programs as joint ventures, and then they dealt with these other issues regarding affiliation and size. And one of the things that a lot of companies don't know is that if you bid on a contract and you get protested, normally, company size is determined at the time they submit their initial proposal, including price. And so whatever happened afterwards doesn't really matter in terms of any transaction the company engages in. Even affiliations that are created don't matter. What matters is what was, you freeze frame the situation that existed when you submitted your price, your proposal, including price. But the SBA has always had a rule that indicates that if you are alleged to be affiliated with your subcontractor on the ostensible subcontractor rule, they'll also look to see what your final proposal revision said. And if the situation changed, because the SBA recognized that between the initial proposal and final proposal revision, you could change the proposal in such a way that you're now unduly reliant upon your subcontractor, or you're giving them the opportunity to perform the primary and vital requirements of the contract. So what the SBA has indicated here is that I want to make clear that they are going to look at your size under these affiliation rules at a different period of time. With regard to the non-manufacturer rule, the reason they're saying they're going to look at different time is because many companies may be proposing to meet the performance of work rules at one point in time, but they're not later. And the performance of work rules are technically not viewed as an affiliation rule, but we do know how to argue that they should be considered. So it takes them, artful drafting, but the bottom line is they're looking to compliance also at that period of time. And also with regard to the SBA's joint venture requirements. This we think is really, really good. The SBA is indicating that if you submit a proposal with your initial price that involves a joint venture that actually was defective, in other words, it didn't include some of the regulatory requirements that the SBA says need to be in these JVs, but you fix it by the time a final proposal revision is submitted, then you are going to be in a position to still be eligible. So we think this was a good change, because we've seen companies that didn't realize when they submitted their initial proposals that there was a little defect in their JV that could lead them then being disqualified. And now there really is some additional period of time. That doesn't mean, though, that you should count on it, because you never know if you're going to get final proposal revisions or if there's going to be a second opportunity to go back to the contracting officer and clean something up as part of the procurement. Also, the second bullet here regarding it allows the Associate General Counsel for Procurement Law to initiate or file a size protest. I think what they're doing here is the SBA wants to make sure that the small business community knows that not only are you able to protest, but that the SBA may be able to protest on its own. They've always been able to do that, but they're giving this right to this attorney at the SBA. His name's John Klein right now. That's a position he's had, and he's the one who actually has drafted a lot of these regulations. What I think is happening is he sometimes hears about things. People will go to him and explain to him how certain companies are not really good actors. And so this allows him to, on his own, begin the whole process. He doesn't have to go through a contracting officer. And it's not waiting to see if a company does it. Lastly, one of the other things that small business rules generally that were changed is that many companies apply to now under the new WSB program, where women-owned small businesses need to get certified. And also services with veteran-owned small businesses may be going through the certification process at the VA, and people who are not experts in size may determine that they're not eligible for these programs because they believe that they're affiliated. And so they make these determinations in connection with a status review, which has nothing to do with size. And so many of these companies now basically are essentially found to be affiliated or disqualified from participating from the program without there being a formal size determination. And it's the SBA who has to make that. So what you need to do if you're applying for these programs, and as part of the evaluation process, they're telling you that they think you're affiliated or you are, you're able to go to the SBA and say, I want a size determination. And so that's something to keep in mind if you realize that you're not being deemed ineligible by a contracting officer or a procuring agency. In the case of really WSBs and SDVOSBs, that is not qualified to do that. Which we thought was great in the SBA's regulations here is they clarified this presumption of identity rule. You know, many companies that are small sometimes have one big client and they get 70% or more of their revenues from that one big company. And that will create an automatic affiliation. I mean, it's called a presumption of affiliation, but it's very hard to get out of it if you get 70% of your revenues from one company. The only reason it was deemed a presumption as opposed to automatic is because you would be okay if you could show that you were a new company. Okay, so if you were a new company as a startup, they would understood that you may rely upon almost all the revenue of one client because that's all you've had. But there was not too much guidance as to what's a new company. Okay, what the SBA has now done is allowed companies that have more than 70% of the revenues come from one source, if they've been in existence for a while, but they have arrangements that are just good arrangements with certain companies that constantly are giving them business, to show that the only reason they are so reliant upon these companies is because they're just, good business partners. It's not because there's anything in the agreement with this other company that forces them to get work from them. And so as a result, this is very easy to get around, because all you have to do is make sure that, if you're a small business that gets more than 70% of the revenues from another company, you just make sure that there's nothing that makes it exclusive and forces you to basically just do business with them. So we think this is a really, really nice change in the SBA's attitude towards the identity of interest rule. The next slide here is regarding past performance. For set-asides, agencies I've been now told that they have to consider the capabilities, the past performance, and experience of their first-tier subcontractors, as well as small business prime contractor. This assumes that the first-tier subcontractor is a small business, by the way. Now, this is in the SBA's regulations. My concern here is that procuring agencies tend to follow the FAR, and so this means that if you are bidding on a contract and the past performance requirements don't allow you to rely upon the past performance of your small business subcontractors, you need to protest as a defect in the solicitation and point to this regulation, okay? Now, these contracting officers may come back and say, no, we have to follow the FAR. There's nothing like this in the FAR. However, there is a GAO case that we know of, actually we were involved in, where these SBA regulations do have to be followed. The problem is a lot of contracting officers don't know that. And that I can understand why they would feel that SBA rules apply to SBA. They don't apply in the procurement world until they are actually incorporated in the FAR. And this is an issue we saw with the subcontract limitation rules and similarly situated rules, that Congress passed a law with regard to these new ways of meeting the subcontract limitation rules. I think it was 210, but it took years for it to be implemented by the SBA, and then even I think more years, like 4 more years before it got into the FAR. For all those years, everybody continued following the old rule because that's what was in the regulations and that's what was in the FAR clauses. Okay, but that's actually a contract administrative matter back then. This is more of a procurement matter on the front end. And ways of doing this is by writing a letter to the contracting officers, pointing this out. You can always have your attorneys write the letter without identifying who you are, pointing this out so they realize that there's a potential for a protest if this isn't addressed. But it does allow now small businesses to team up with other small businesses and have the past performance of their subs counted. One of the other areas where the SBA made changes is the recertification rules, which we've been dealing with this for a while because we're seeing more and more agencies that are asking actually for recertification either at the task order level or even during the first 5 years of a contract. And the SBA, one of the things, a position the SBA took about a year ago was that if your status changes, not only does it mean that the agencies can't get credit as small business set-asides, but you can't continue competing for the work. And that's not the way the regulations previously had been written. The way the regulations had been written is if you had to recertify to no longer being small, the agency just couldn't take credit, but you continue performing the work and bidding on contracts, absent an actual request for recertification. Well, the SBA is taking the position that no, once you're no longer, you can't continue competing for the work, and that really changes your status. One of the other things the SBA did here is with regard to joint ventures. Now, the way they've changed this rule is a little bit still ambiguous. They wanted to clarify that if you're in a joint venture and one of the parties of the joint venture is acquired, then that party alone needs to recertify. That's the way this current rule is written. Under the rule, it's been in the books for a long time. Now, if one of the parties recertifies to no longer being small and the status of the entity, the joint venture, was based upon the small business status of both, then the joint venture had to recertify again. And if it wasn't no longer small because one of the companies was no longer small, then it technically wasn't eligible either. The SBA has indicated in this rule that only the status of one party changes. But if you look at their background discussion of the new rule, it looks like they still didn't mean to change the fact that the joint venture status also changes. But that's not what they said in the rule. And so we're going to be going back to the SBA for some clarification on this, because it's really problematic that now people may read the rule as currently written and think, oh, the joint venture is out of the woods if just one of the party status changes. When in fact, if you look at the discussion from the SBA, we submitted comments to the SBA on this rule. We wanted them to interpret it a certain way, and the SBA said no. So we see a disconnect there. And by the way, there were technical amendments the SBA just recently issued. So they're making some additional revisions to these regs because they've noticed that there are typos and certain words that were not put in the right places. And so they are going to clean up the regulations, and they might clarify this right now. Right now, because of the way it's written, it's still somewhat problematic. The other thing the SBA did here was they wanted to deal with situations where companies are being acquired during the period of time that they have proposals. And this is problematic for many companies that are competing for contracts, which are very upset when they all of a sudden realize that they've lost to a company that's been acquired. Now it's a large business doing the work, even though they thought they were competing with small businesses. And so what the SBA has indicated is that if you go through a change of ownership during a period of time you submit your proposal and the actual award, before the award you need to recertify. And the SBA recognizes that these procurements sometimes take a significant amount of time. And so if these transactions occur within 180 days of the proposal submission, you will not be eligible for the award. However, because sometimes these transactions take so long, and the SBA recognizes they may never take place, if it's more than 180 days since the date you submitted the proposal that the transaction closes, then you can still get the award, but the agency can't get the credit. Now, the issue is that that's going to be a big problem for your customer if that's what happens. Now, this may not be relevant to many of you because it's just you're not in that world right now. But we do see this because there's a consolidation going on in the government contracting world, and so we're seeing a lot of M&A transactions. And we're normally focused on the contracts companies have, not the proposals they have submitted. But sometimes these are big proposals on big contracts that are follow-on. With regard to the small business rules generally, one of the other rules that was changed here is that they've indicated that if you're an Alaska Native Corporation or a tribe or Native Hawaiian organization and you're moving one of your subsidiaries around to another one of the companies, that's not going to require that the SBA's prior approval for a change. That's not going to require recertification. There was also a change of ownership component, but also they're not going to view that as triggering a recertification. And lastly, one of the things that the rule has, which I think is somewhat bothersome, is it indicates that a contracting officer can request size recertification at any time. And the way the rule reads is prior to the 120-day point of the 5th year of a long-term MAC, meaning they could actually do this within 1 or 2 years of the initial award of a contract. And we have seen actually that the VA has been doing this to companies that have received contracts of only 5 years. And even though they're supposed to be small for the life of the contract, they may on the 2nd or 3rd year say, we want you to recertify before an option is exercised. These companies have grown naturally, and now they recertify to being large and they can't compete anymore. And which is disturbing because the SBA in the comments to the rule indicated that they believe that companies should benefit from any award that they received when they were originally small. Yet they've given contracting officers tremendous power here to essentially winnow down the competitive field of companies that are competing for work early by just requiring recertification, because they go to SAM, they see, oh, of all these companies on those multiple awards, 6 or 7 of them are large. According to SAM, someone asked for recertification. Now they only have to give you 3 or 4 proposals. And we don't believe they should be allowed to do this. And I've been telling clients that they should protest this because I don't think that's what the SBA intended. But then they issued this final rule, which suggests otherwise. So I think, I don't know if the SBA really connected all the dots, if this is even being done on single award 5-year contracts. Another issue the SBA wanted to tackle, and this is really getting into the weeds of the regulations, is with regard to multiple award contracts and making sure that they're being assigned the appropriate NAICS codes. And there's a whole system that they're trying to create here to make sure that if a multiple award contract is going to be awarded and there are going to be multiple NAICS codes, that has to be very, very clear. And then to the extent orders are then later issued under this MACs, that there has to be a NAICS code assigned under those orders as well, and that they should be tied to the principal purpose of the contract. One of the things the SBA, we believe, SBA has been seeing is the way multiple award contracts have been gained, and some contracting officers aren't following, engaging in the appropriate and NAICS code designations. And so one of the things the SBA has done also is that companies can go to the SBA through either a formal size determination process or the appeal process to make sure that someone is looking at how the agency is going ahead and assigning NAICS codes to these multiple award contracts. One of the other issues that the SBA has indicated is they recognize that there's a lot of these multiple award contracts that are competed on an unrestricted basis. Small businesses are not competing for the work. They may set aside some of these task orders for small businesses, and no one can really, under the rules that have been existing in place, could protest the size of these companies, even though they had grown to be large, because they were small at the time they were originally awarded the MAC. And the SBA has recognized that just because you were small at the time you were awarded a MAC on an unrestricted basis, doesn't mean though you shouldn't be qualified as a small business at the time you're submitting the proposal on underlying task orders. So, and or be a service-disabled veteran 8A, you have to qualify within the status. And so what they're trying to do is close this loophole where agencies were using MACs, making multiple awards, but then engaging in more limited competitions among certain groups of firms, where some of those firms may not even be eligible, but they were relying upon their original certification. So they're trying to close that loophole. Switching now to the 8A program, for those of you who are 8A or doing work with 8A companies, one of the biggest changes we've seen in the rules, there was a lot of them, but one of them is the fact that for some years now, the SBA has really frowned upon companies entering the 8A program where there was an immediate family member that had been in the program before. At one point in time, you just couldn't even get in the program if you had an immediate family member in the program. But then they changed that rule some years ago, and they allowed an immediate family member of a former program participant to enter the program as long as they weren't doing any work together and really were even engaged in separate lines of business. I think the SBA heard from so many different companies saying, well, this is so unfair to the family members, they should be able to get in, et cetera. So the SBA actually really relaxed the rules significantly that even now, to the extent that an immediate family member can get in the program and do business with the family member who was in the program. And so long as the transactions are arm's length transactions, they should be okay. And it shouldn't be a problem. Now, this is, I think, interesting because we've been hearing that under the incoming, Biden administration, that they're going to be pushing more and more work to small businesses and to small disadvantaged businesses. And we've been seeing a significant uptick of companies applying for the 8A program. I would think this is going to mean even more companies applying for the 8A program, because if you really know how the program works and you know how to get the work done, you have an immediate family member who wants to be involved in the program. I could see this, resulting in a lot of companies now trying to get in the program and immediate family members. I see potential for abuse, of course. So I think these companies need to be very careful what they're doing because they may be still in targets of protest and or SBA reviews. But this does open the door for more companies to enter the program where they have immediate family members. The next issue that the SBA also dealt with was they made it easier to have changes in ownership in 8A companies. The way the regulation is written, so long as it's a change of ownership of less than 20%, although there are examples the SBA does give, because if you look at the way the regulation is written, it looks like it only applies where you have a former owner that held less than 20% and the transaction is at that level, or where the disadvantaged individual is actually going to get more because they're buying out of one of their current owners. But in fact, if you look at the example the SBA regulations give, a current 8A owner can actually bring in somebody at, for example, 10%, and they don't need to get the SBA's prior approval. Even though they're going to be getting less of an interest, they're going to have, as an 8A owner, they're going to have less. If it's only at 10% and they're still owned 51%, it only doesn't require SBA's prior approval. It only requires that you notify the SBA. And changes of ownership at the SBA can take a while, 8-9 months. Many companies do need to bring in owners who want to invest in them. So it's a good source of raising capital, but the SBA made it very difficult. The other issue we think is very interesting here under this, what's happening with the SBA, with potentially more companies entering the program. under the rules that have been in place for years, if you were denied admission into the 8A program, you had to wait a whole year to apply again. And so many companies, if they realized that they really weren't eligible, they would wait, and make sure that they, were perfectly, well equipped to deal with the review process, and then pretty much guaranteed to get in. But now I could see companies deciding that they're not going to worry about it. They'll throw in an application, and they may just have to wait 90 days, see what the SBA says. If they get in, they're in. But if they're not, but they now see all the problems with their application, they just resubmit again. And you're allowed to do this under this new rules up to 3 times within 18 months. But if you do that, then you can't apply for 12 months later. But I think this is going to, again, incentivize more people to try to apply for the program, because they realize that if you're not eligible, and the reason you're not eligible is a really big one, that you really need to wait a year or whatever, then you just wait. Such as if you're not likely to succeed in the program, then you're not going to be able to just apply 5-6 months later. But if it's some other technical reason, I see the SBA also denying a lot more companies because they know they can reapply. So rather than engaging a lot of back and forth and Q&As, I can see the SBA saying, no, you're denied, and then now you know why, and you go back and fix it. So I can see how this can work to the advantage of both SBA and other companies that are trying to apply for the program. Also, one of the other things the SBA has done here is with regard to the bona fide place of business rule. This is for construction companies. The SBA recognized a lot of companies were actually losing opportunities because the SBA wasn't engaging in a review of whether they had a bona fide office where the construction work was going to be performed in the geographic area. An award still needs to be made after the determination is made by the SBA that you have a bona fide office where you're bidding for the work. However, under the old rules, you really could not submit a proposal if you didn't have the bona fide office. But now, if you've requested that the SBA do a bona fide office review, and it hasn't been done before your proposal is submitted, you should still be okay. The agency just cannot make an award until they've confirmed from the SBA that they've done the review. And so this is, one of these other rules that we think is very, very good for 8A companies that are in construction field business, that we're finding that the SBA just was not. Staffing issues the SBA has been a problem with. I think they recognize that. One of the other rules, and I think this is the last slide, hopefully I can take some questions here now, is that with regard to the business activity targets, for those firms that are in the 8A program, once they've entered the program, towards the last 5 years of the program, they need to be achieving these competitive mix goals where they're getting less and less 8A contracts. And if they're not able to meet those goals, the SBA would normally just say you're not allowed to get any more sole source contracts. And that was very problematic for companies that had perhaps been marketing several 8A sole source awards, and now they were subject to this prohibition. And the SBA has decided that they're not going to be that strict about that anymore, that they need to be more flexible. So we found that a lot of our clients, were being hit hard by this rule, and now the SBA has indicated that they're going to be a lot more flexible in how it is that they go ahead and apply it. So companies should still try to, of course, meet the goals. But the other thing the SBA did was they did change the goals a little and relax them so that the percentages aren't as high, but not the changes aren't that big. It's only been like 5% reduced in the last 3 years of the program. Instead of like 35, 45, 55, the percentages are now 30, 40, 50. So that basically sums up all the changes in the regulations that, well, not all of them, the ones that I thought were the big ones that I could go through for the benefit of the group here, that hopefully some of you get benefit from some of this material, and other material may not be relevant to you, but you will know what other companies are doing and having to deal with. Okay, well, if you have any other questions from your group, I'd be happy to take them down the road. You can, my email, you can get it. It's afranco@PilieroMazza.com. If you go to our webpage, I think the material here may be distributed as well, so I think it's all there. I'd be more than happy to answer any questions that you guys have down the road. There's a lot of material here, and this is really a sort of superficial just highlight of the rule changes.